now sitting at Boston Whitman and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning, everyone. This is the December 2nd, 2025 sitting of this panel of the Appeals Court. I am SEMEDO Singh. With me is Justice Marguerite Grant, and here with me is Justice Gloria Tan. We will be your panel for today's sitting. Today we have 5 cases that will be argued, and we will, I think the parties are all clear that each side has 15 minutes. There are no rebuttals. And so I call on the first case of Commonwealth versus Barry Lee Farris, 24P 782. Counsel, please approach.
May it please the court. Good morning, Your Honors. Jennifer Peterson on behalf of the defendant appellant, Barry Lee Farris. As I'm sure Your Honors are aware, this was a close case that turned on the credibility of the parties. So it's especially important in cases like this that the Commonwealth not exceed established parameters for their closing arguments. And in this case, they did. And by close case, 11 counts were indicted, 3 were null-prossed, 2 were directed out, so 6 went to the jury, and of those 6, they returned 2 not guilties. So it was a close case, like I said, that turned on credibility. With respect to the oral argument, Mr. Farris, as the record shows, was essentially functionally bedridden. He had spina bifida, he was diabetic, he had a number of health issues. He was incontinent and was required to wear adult diapers.
But he worked, and he testified that he was at work when some of these events would have taken place.
He did work. He worked as a security officer, and that work involved essentially driving in a vehicle. So he did drive. The work that he did was seated. And he could get around on crutches, but he needed assistance or to lean on things and to stand. He had a difficult time standing. So he spent much of his life in bed. With respect to some of the errors, the Commonwealth started by appealing to the sympathy of the juror, saying things that from a young age no one cared about the complainant, and that the only person she really thought cared about her and loved her was the defendant.
There was no objection, correct? The defendant didn't object at trial?
Yes, there were. There were, to the closing argument in general, there were objections, yes. To the burden shifting, I think some of the specific arguments that are raised in here in the brief were not specifically objected to. But in general, counsel did object to a number of different errors, which the court overruled and said the judge said he would give an instruction that it was the juror's memory that controls.
Why don't we be specific as to which particular claims here were objected to? You started with sympathy, the sympathy argument.
I think counsel objected to burden shifting, and specifically she said that Mr. Farris had no obligation to speak to the police. Because in closing argument, the Commonwealth argued that the first time Mr. Farris told anybody that he worked the second shift was at trial, as opposed to when he talked during the police interview. Mr. Farris, the testimony was essentially he worked both shifts. Sometimes he worked second shift, sometimes he worked third shift. So the defense counsel objected to the fact that he's not required to present any evidence. And for the Commonwealth to suggest in closing argument that he needed to or that he needed to present more was improper. Also, she objected to saying nothing about having migraines. The migraines was significant, I believe, because on the night of the alleged assault, right before they went to the hospital for the sexual assault exam, they claimed that she said that she was in there for a migraine. The grandmother testified that it was a migraine, not the child.
But so, I guess back to Judge Tan's question, when the defense attorney objected to the Commonwealth's closing argument to the extent that it mentioned that the defendant had been impeached with his prior inconsistent statements on cross-examination, and that the argument was that that was burden shifting to do so, did that save an objection to what the defendant argues here, that it was burden shifting to say what benefit did the victim have from testifying?
Well, I would disagree that it was a contradictory statement. Just because it didn't explain all of, I mean, the context of the interview may not have included that he worked different shifts, but I don't necessarily think it contradicted that. But as far as the burden shifting, even if we don't get prejudicial error standard of review, I think these, in a case that's so close like this, I think substantial risk of miscarriage of justice is met here, especially with respect to some of these arguments. I would point to the DNA situation where the prosecutor argued that the DNA, well, first she says, with respect to the body and the abuse, that any sexual activity, if you do it over and over again, your body becomes accustomed to it. Like if you play the guitar and your fingers get red over and over again, it stops happening. There was no evidence from either one of the medical people that said if you're raped over and over again that your body becomes accustomed. And the reason there's no evidence is because it happens so frequently. There was no evidence of that whatsoever.
Was there any evidence that the victim was ever in pain as of what the defendant did, as a result of what the defendant did to her?
I believe she testified that when there was anal penetration that she experienced pain. But the examination said that there was absolutely nothing. They spent a half an hour with a med scope which illuminated and also magnified the whole area. There was no abrasions, no scarring, no evidence whatsoever, even though it happened 6 hours. The exam was 6 hours after the last alleged incident. And the testimony was that the hymen could heal itself, but it would take 3 to 5 days.
The indictment on anal penetration was null prost.
Yes, but I believe there was still testimony about that, even though which they talked a lot about that she was examined. The complainant was examined. Excuse me? Oh, she thinks it came from the sane nurse, that's where it was in the record.
Well, so I guess when we're thinking about prejudice from the closing argument, does the fact that there were some not guilties, doesn't that show that the jury used some discretion or didn't buy the prosecutor's argument completely?
I can't pretend to know why the jury came to its not guilties, but I think theoretically it could cut both ways. I mean, they may have been on the fence about these, and the closing argument, which can be very persuasive, may have pushed them over the edge, especially when it comes to the whole DNA thing. Especially the prosecutor's argument about, you also heard from multiple witnesses that if you pee and you defecate, there's a possibility there could be some DNA there. But you also get to use your life experience and common sense that if you're urinating and defecating and wiping yourself off, how much, if any, DNA is going to be there? Now, I don't know, jurors, I would argue, do not have life experience about the quantity of DNA that would be left on the body after wiping themselves, after toileting. And the part of the record the Commonwealth points to has to do with the fact that there were two witnesses that sort of spoke to this, but one of the witnesses was asked about whether going to the bathroom would affect the presence of biological fluids, and that testimony was not allowed in over the objection of defendant. And the other one said only that wiping or peeing or defecating, those type of factors could affect how much DNA is there in the sample. Well, in this sample, there was no DNA. There was no DNA around the vagina, around the anus, or anywhere around her.
It was on the lower abdomen.
The lower abdomen had some evidence of saliva and seminal fluid. And the facts, as they came out at trial, indicated that the complainant had wet herself that morning. The family used towels and washcloths. They all used the same. That the defendant had cleaned himself with a washcloth the night before after sex with his wife. And there's the possibility that A, it could have been transferred from the washcloth, or B, simply from the bedding. There was no DNA found around her genitals whatsoever, and that's what was alleged was taking place.
But what do we do with the testimony of the sane nurse expert who said that seminal fluid and saliva would only be transferred when wet?
I don't think it was only when wet. I think it was more easily when wet. And I would suggest that that's where the washcloth comes in, when the child was washing herself and cleaning up that morning before her day, after she had a problem with the bedwetting. So that's what I would suggest is possible. Theoretically, they said that there could be dry transference too from the sheets and stuff like that. So it wasn't exclusively wet. It was just more easily transferred while wet. And with respect to the lack of sexual knowledge, the Commonwealth argued in closing, like how would she know about these acts unless she had been abused by this man? However, prior to trial, the Commonwealth filed a motion in limine requesting that defense counsel not be allowed to cross-examine the complainant. The defense counsel said he understood about rape shield, but there was information not just, and the Commonwealth refers to self-serving statements made by the defendant in his police interview, but the Commonwealth also was aware that there was DCF records, which suggested that she had been sexually molested 3 other times. And
do we have the Commonwealth's, the motions in limine about these prior incidents in the record appendix?
I don't know if that was included in the record appendix. It's not.
Right.
Okay. Because I have a copy of the motion in limine that was filed. To the extent, though, that is there, I don't think it particularly references the DCF reports. But in the record itself, defense counsel speaks to the fact, and it's in where they're discussing the motion in limine. Defense counsel specifically says, I would like to be able to reference this, and the court left it, I'm not going to rule on this because of the DCF. So it's referenced in this.
The judge said, I'm not going to rule on it yet.
Yet. And if it comes up at trial.
Right. And then defense counsel cross-examined the victim about other males who were possibly in the apartment at the same time, and she said, I don't remember him, I don't remember him.
Yeah, and there was a little bit of tangential stuff, but nothing really got to these allegations and the false complaints and stuff like that existed in the DCF records. And it didn't really come up at trial, so there would be no reason. The prosecutor didn't raise it at trial, so there'd be no reason for there to be an objection by defense counsel. However, in closing argument, that's when.
But so the prosecutor basically said, does it make sense that a 9-year-old girl who refers to her genitals as her privacy and to a male's genitals as his boy thing, does it make sense that she would be able to make up these allegations? Why is that improper?
I think what she said is that unless he had done this to her, but why would she do that when she had been exposed to other times of abuse, or at least according to her mother, she had been sexually assaulted previously, and also that she had been watching pornography, found watching pornography. And
So did the defendant call the victim's mother to say that?
No, that was part of the whole ruling, that if, Rape Shield would come, and this happened in closing argument, so they wouldn't call because of the whole Rape Shield thing. There were allegations she was sexually active with her younger brother, and there were a lot of issues that the Commonwealth wanted to preclude through its motion to eliminate, and defense counsel was aware of it. So when it came up in closing argument, this argument came up in closing, defense counsel has no remedy at that juncture. So if the court has no further questions, I'd rest on my brief.
Thank you.
Thank you, Your Honors.
Good morning. May it please the court. Hallie White Spate, Assistant District Attorney for Middlesex on behalf of the Commonwealth. First of all, none of these claims are preserved. The defense counsel had 3 pages of objections at the end of the Commonwealth's closing. Absolutely none of them touch any of the claims that are raised here before this court. So the only review is for a substantial risk of a miscarriage of justice. I don't need to rehearse for you all of the cases that say where there's no objection, we take that as a sign, particularly highly experienced and zealous defense counsel as tried this case. It's a sign that the inflammatory impact was not what it's now being made out to be.
Well, I don't think that the argument so much is inflammatory, but, for example, burden shifting.
Some of it is claimed to be inflammatory, some is claimed to be facts not in evidence, some is claimed to be burden shifting, which absolutely none of this is burden shifting. There's no burden shifting here, unless we're going to say that any time a prosecutor asks a rhetorical question in closing, it's shifting the burden to the defendant to produce some evidence about why the rhetorical question should be answered in one way and not another. I simply don't understand how any of it is burden shifting what's claimed here.
How do you respond to defense counsel's argument about the guitar analogy being improper?
I don't think it's improper. There was testimony there was no specific testimony in those words that your body gets accustomed to it. But there was testimony that the hymen can heal, testimony that it is entirely normal and expected to find no sign of trauma or injury in a child who's been raped, and also that even with repeated abuse, you would not be surprised not to find injury.
What I don't understand is, how does that then create an inference that it's like playing the guitar? Because as I understand it, when you play the guitar, the metal strings hurt your fingertips and they become calloused. There was no evidence of injury here, so how?
Yeah, I think the argument was somewhat inartful, and in fact, I had the same thought that this isn't making the case that you want it to be making, and in fact, what the evidence shows here is kind of the opposite. But I don't think that that's actually more harmful to the Commonwealth by creating this inference if you say, wait a minute, I played the guitar when I was young and my fingers got really calloused and blistered, but there was no trauma here. I think it's not especially prejudicial. It could be more prejudicial to the Commonwealth than to the defendant. But I don't think it's so far outside the scope of what was testified to. There was testimony that these tissues are meant to stretch and bounce back. And that's more or less what's being talked about here when the prosecutor talked about your body gets accustomed to it. To just speak briefly to the question of the lack of sexual knowledge, there was no assertion that this was the only way she could have known what was happening to her. And in fact, it's more of it's kind of the opposite. She didn't know what was happening to her. She was 9 years old. She had these childlike names for her body parts at the time. And I think the prosecutor was also entitled to explain that the terminology she used at the time of the rape examination and in the medical records, which went to the jury, was different from what she testified to. By the time she testified at trial, she was I think, well, several years older. She was in high school, and she was able to say vagina, anus, penis, and I think the prosecutor's entitled to explain, like, this is the way a 9-year-old thinks about it. You didn't see a 9-year-old on the stand. You saw a 17-year-old. And the relevance of that is, in some ways, not what it usually is in these cases, and this is not a case where we're saying, why would she, and again, to go to the supposed, I think this was supposedly burden shifting of what was the benefit to her of doing this. This is not one of those cases where the Commonwealth said, why would she come in here and testify? Why would she tell anybody if this wasn't true? In this case, she didn't tell anybody. And the relevance of this is to explain why she didn't resist, why she didn't tell anybody. Because she was so vulnerable, she had such an unstable life, she truly was neglected. If the implication was absolutely no one on the planet cared about her but the defendant, and I don't think that's the only inference from the way this was argued, but even if that's the inference, that's, I think, excusable hyperbole, because what happened here was that he did have a position of trust. He did care for her. He was her primary caregiver in some ways, in ways that her own mother was not. And that was why she submitted to him, because she didn't know it was wrong. I don't know if the court has other specific questions about parts of this. There was testimony that going to the bathroom could affect the amount of DNA. None is an amount. It's entirely supported by the evidence. But the DNA was found on her stomach, a place where you wouldn't wipe after going to the bathroom. The defendant's story about how she'd wet herself and he sent her into the bathroom to clean herself up was entirely the defendant's story. She did not testify to that. She did not testify to having a migraine. The fact that the defendant had his own story to account for his DNA being on her abdomen, her lower abdomen, does not mean that the Commonwealth is not entitled to present its own interpretation of that evidence and argue to the jury about why that evidence should be believed. If there are no further, is there?
I have a question.
Yes, please.
Sort of a rhetorical question. Both the defendant's brief and the Commonwealth's brief refer specifically to the Commonwealth's motion in limine about the victim's prior sexual knowledge. In the Commonwealth's brief, it's at page 22, note 2.
Okay.
That is not included in the supplemental record appendix.
Is it not? Okay.
I understand you didn't write the brief.
It should have been.
Rule 18A2A requires it to be included, and the certificate of compliance with the rules required the assistant DA who did write the brief to certify that he had complied with that rule. It's really important that people comply with those rules.
I agree, and I'm happy to get the court a copy of it. I know you can get it yourselves.
It's not necessary.
But yeah, I apologize on behalf of ADA Ferreter for that. It should have been there, and I don't know why it's not.
Counsel, I know you've gone over this a little bit before, but I just want to be more specific about this. One of the allegations is that the Commonwealth statement in closing, and I'm just reading from the bolded portions in the other brief, does it make sense that an 8 or 9-year-old child would know the intimate details of how intercourse occurs? Is it proper to make that comment knowing that there exists allegations of prior sexual conduct?
I think given, and my understanding from my knowledge of the record, which I admit is imperfect, that there was no credible support for allegations of other sexual activity.
Well, who makes the determination of credible support?
It's a question of good faith basis, I think. And my understanding, just from what I have seen of our filings, and if I am wrong about this, I am wrong about this, was that one of the reasons we wanted to keep this out was that there was no good faith basis for it. It was simply the defendant's assertion, which was why we referred to it as self-serving statements.
There were DCF records relating to that as well, correct?
I think so, but I have not seen them.
Okay. But if there were DCF records indicating prior sexual conduct, then that would be improper to suggest how else would she know of this?
I think, well, it's certainly close to the line. I think, but again, I think the thrust of this is not, it had to have happened because otherwise she wouldn't have known it, as why did she not think it was wrong? I think that is the clear thrust of the argument there. And perhaps that's, again, a bit inartful, but I don't think, it's certainly not a ground to reverse the convictions. All right, I'll rest on my brief and ask the court to affirm the judgments. Thank you.
Thank you. Thank you both. The matter is submitted. The next case is Commonwealth versus Jonathan THEOGENE, 24P 1395. Counsel, approach, please. And I neglected to mention this for the earlier case, but it applies to this case as well. There are impounded matters here, so parties just be mindful of that.
To the presiding justice, and may it please the court, with your permission, I'll begin with the contempt issue first. 2 issues here. Can the court do what it did with respect to contempt, and how does that, and then how does that apply to Section 33A and jail credit? So in this case, I'll just start by reading from the rules of civil and criminal procedure. Civil procedure rule number 1, quote, "These rules govern the procedure in all suits of a civil nature." Rule 1 for the criminal, quote, "These rules are applicable to the criminal process," end quote. So the problem here, as you can see on the record appendix, page 57, is that the court specifically used a civil contempt proceedings as open-ended to keep open the sentence. Under criminal procedure, all the court can do is, under Rule 43 of the rules of criminal procedure, is issue a fine or prison time. In this case, he'd already been found indigent. He'd already been incarcerated.
But the judge found, though, right, that it was actually civil. In fact, she wrote specifically on the motion in a margin endorsement on, I believe it was in July when they came back, right, the 1-month date. And she found that it was actually under civil rules of procedure, civil contempt 65.3, not under, even though the Commonwealth initially filed their motion under Rule 43, right?
Under 43? Yes.
Right.
That's right.
Right, and the first initial date, and in fact, the judge, I know, issued a written findings after that, and she also adopted the Rule 43. But when they came back for the month sort of status date, right, they discussed it. There was a new defense counsel. He raised it, and he asked the judge to revisit the issue. And that's when the judge said, no, it's civil. And she wrote on, right, on the motion in denying the defendant's motion that it's under civil contempt?
So I guess then that asks the question, when can you use civil versus criminal? The problem here is I don't think you can legally use civil contempt in a criminal proceeding against the defendant. The criminal procedure says that the rules of criminal procedure apply. Now, I understand that a court has, in a civil case and in a criminal case, it has those procedures laid out. There's even a kind of a third carve-out that I would point out, that is the judge's innate ability to keep order in the courtroom, derived from the common law, but that can't be used here because this is a criminal procedure.
What legal authority do you have for that argument?
There is no case that really says that, as both of our briefs show. But to allow a judge in a criminal procedure to just change from criminal procedure to civil procedure, I mean, the criminal procedure is already there to try to force the defendant to comply with the court order. And I'll also just point out that even the tap of the phone did get the government some information.
But not all, but not because the defendant
not all of it, I
provided
understand
or
that.
complied with the order, right?
But it's the defendant who has the ability to comply. My client maintains that he forgot the password. The court didn't believe him. And so from there, the procedure is you can hold him in contempt under 43. If they think that it's worse, then you can bring up an indictment under 44. But you can't just switch all of a sudden to criminal, or from criminal procedure to civil procedure just to keep it open-ended. That's the problem here. It's a criminal procedure. There's due process rights that the defendant has that are completely ignored if the court is allowed to just jump from criminal to civil when it wishes.
So are you saying that once a criminal case has been initiated against the defendant, he can't be found in civil contempt for any reason?
In a criminal procedure, yes. That's our position, is that.
But how does but how would the court be able to enforce or compel a defendant, exactly like in this case, to follow a court order, right? Isn't the criminal contempt really, the 43 and really 44, aren't those statutes directed at contempt of when a defendant sort of does something in court and swears or acts out, or there's behavioral, some type of contempt in front of the judge, and that's when, as opposed to coercive, it's more of a punitive, right, contempt, as opposed to a coercive compelling the defendant or attempt to compel the defendant to comply with the court order, as a civil contempt under 65 addresses.
Yes, but in both the civil and the criminal, the court has tools at its disposal to try to force the defendant to comply with its order. In a civil case, not criminal, where it's you're litigating over assets or money, yes, it does allow for a much more open-ended process, and the judge is given much more freedom to kind of craft a punishment or a way to get the defendant to comply with the court order. However, in the criminal process, it only has two tools at its disposal. It has 43 and 44, and that is it. You can't just you can't jump from in a criminal procedure to the civil rules. Again, the very first rules, they say, these rules govern criminal procedure. These rules govern civil procedure. Now, I understand in that third carve-out that I talked about, where the judge has that innate power to keep order in the courtroom, this is not an issue where the defendant was getting up and yelling.
But hypothetically, let's say at a pretrial hearing, the defendant had stood up and yelled obscenities at the judge, and the judge had said, custody. I hold him in contempt in my presence. I want him locked up for 24 hours. Would the defendant be entitled to credit for that 24 hours, even though it's a different incident than the crime?
No, once a defendant is found in contempt, I think there's an argument to be made that that time would not be credited. But in this case, none of that ever happened. I mean, here, had the court followed Rule 43, those 3 months could have been taken off the credit. But That was never found, that procedure was never complied with. What the judge specifically did was just use the civil contempt, as far as I can tell, to just hold open that, that time to be applied at the end, which is.
So your argument's not that the credit can't be told, like that the judge was improperly subtracted the amount of time that he was held in civil contempt. It's that the actual type of contempt in this case that was imposed was incorrect.
Procedure is important.
But I'm just trying to get what your
procedure is
argument
important because
you're
under,
not contesting the idea that once you're properly found in contempt, that contempt period can be subtracted from the jail credit.
let me answer your question this way. I am arguing that in a criminal procedure, a court cannot apply civil contempt to a criminal defendant to specifically hold open or toll those credit days. Now, had the court applied or had the court found him in contempt and under 43 and said that those 3 months are being applied under 43, then there's an argument to be made that that those 3 months would not be those 3 months could be held under the credit. But that wasn't what happened here. The court just independently said, we're going to use civil procedure. We're going to hold open this, this contempt, and we'll just deal with it at the end. Where the rules clearly say the court's options are to hold him in contempt, fine him, imprison him, or go under summary contempt and seek an indictment. Those are the tools that are allowed a judge in a criminal case. Those tools are lessened with this defendant because, like I said, he's already been found indigent, he's already being held in incarceration. And so the court's power is lessened in this sense, but if it wants to, it could seek an indictment. That definitely has effect on a criminal defendant. But procedure does matter. I've never seen a case, nobody has cited a case that says that a judge can, in a criminal procedure, jump to a civil procedure rule used in a criminal process. I've never seen that before, and if that's what the court holds, then this is interesting and new ground. Section 33A requires credit to be given. And while if a court wants to withhold that credit, it could under criminal process, like I said, those 3 months, that never happened in this case. And so the defendant is entitled to the full, his full credit. Are there any questions with respect to contempt?
Just one issue. I think you stated that your position is that a judge can never use civil contempt in a criminal proceeding against a criminal defendant.
Yes.
Okay, and it's not, but I thought later you said that a judge can't do it in order to keep the matter open.
Against a criminal defendant, in this case.
So it's absolute. That's your position, that it's absolute, whatever the purpose is, that the only remedy a judge has against a defendant, whatever behavior is going on, or behavior is sought to be compelled, it's got to go through the criminal contempt process.
So looking at the case law on contempt, I do recognize that there is this innate power of contempt in a judge that is not derived from the civil rules and is not derived from the criminal rules, that a court has the ability to keep order in her courtroom. But then in that situation, you need some event where the defendant gets out of hand. Well, no, I mean, that would apply, I think, ultimately to not the defendant, but like others, maybe a witness or maybe somebody in the gallery. But as far as it goes for the defendant, the court's ability is to get him to comply either by imprisoning him, fining him, or seeking an indictment.
And you're saying you've found no authority either for that position or really
I've never seen any cases that allow a court to jump in a criminal procedure, and certainly in a civil procedure to criminal, but in a criminal procedure to civil. That's what's odd about this case.
What happened in Gelfgat? I don't remember, but didn't they say you can hold the person in contempt until they turn over their passcode?
Yes, you can, but again, we're looking at the rules as they're applied. you have a statute that says that he gets jail credit, but with respect to that case, you have to comply with the rules.
So you're saying that we should interpret Gelfgat to mean that the judge can only hold the defendant in civil contempt? I mean, criminal
No,
contempt?
in criminal, in criminal. Otherwise, the rules seem meaningless in this.
Then what, if the defendant is being held and knows that any time he's being held is going to go toward his sentence on the underlying crime, what motive does the contempt give him to comply?
Well, again, under the way that it's set up, his motivation is those tools of coercion, either a fine or imprisonment.
But it's the same length of time of imprisonment as he's going to get eventually.
But under the civil or under the criminal rules, it's a 3-month sentence. That's what the court can impose, a fine of $2,000 or up to 3 years or 3 months. Again, this is just to coerce the defendant into complying with the court order. He's not being disruptive in court. All he's doing is saying that he forgot his password. I understand that the court didn't believe him, but nonetheless, he can stick to that, but the court still has, under the criminal procedure rules, it's those tools only available to it. It can't just broaden that by jumping to civil and saying, well, we're just going to hold this open indefinitely.
Just briefly on the Snapchat.
Yes.
Why couldn't Judge Deacon conclude from seeing the victim's demeanor on the video that the banners she was typing were under the influence of an excitable event?
It's a good question. So hearsay is bad in a criminal justice system because it allows falsehoods to enter in through evidence that can affect the jury. Excited utterance is designed or it perpetuates the idea that if somebody is so shocked by an event that they can only utter the truth. And that's why it's allowed. Now, I understand that case law has pulled that out longer times afterwards. It's even been applied to text messages. But in this case, the problem is you have a video that's taken, and my client would want me to add that it's not known when the video was taken. It could have been taken before, quite a bit before. But the event of taking a phone, taking a video, even looking at it as contemporaneous, taking a video, then you have to take that video, upload it to Snapchat, and then you have to pick banners, type them up, and then choose somebody to send it to, which is what she did. She sent it to the roommate.
If
If
she had dictated the banners, would your argument be different?
No, I don't think so, because it's the time and the complexity of taking out the phone and using it to the point where you're going to upload something to social media that...
But isn't Snapchat now a way of a pretty widespread way of communicating amongst, sometimes the younger generation, I'll say, right? But isn't it akin to just texting something? And you can see from the video, even though it's short, she's whispering, she's crying. You can hear something in the background, possibly, I think, a reasonable inference that it might be the defendant, right? And she's actually whispering so that you can draw an inference that she's afraid, she's still under the influence of the event, the so-called exciting event, and that she's perhaps texting, but putting it in writing because she's afraid that she's not in a position to be able to talk. She's whispering, right? Is that not?
No, the complainant can bring in the video. That's not the question here. The question is the banners. And the problem is the upload to social media and the idea that this is coming in for the truth of the matter asserted. The complainant testified. But the problem with the banners is they're so far removed from the event just by taking your phone out and uploading it to social media that it almost, I mean, if this is allowed, it's tough to imagine any excited utterance that wouldn't be allowed. And that's the problem. The rule is there to be a bright line, somewhat blurred these days, but there to be a bright line to make sure that these types of falsehoods don't go in for the truth of the matter asserted to the jury. That's the problem with
So are
hearsay.
you saying anytime something's typed, it can't be an excited utterance?
No, there's case law that says that. But so, for example, I guess the difference here between this case and the cases that talk about, texting an excited utterance would be a person who texts an excited utterance is the cases that I cite in my brief are immediately to somebody specific warning of danger. But again, the problem here is it can be different with social media because of the steps that are needed to go through. The steps that are needed to go through, especially with a video and adding banners, again, that's the problem. You have so many steps that it allows the brain, the brain is clearly functioning. She's uploading something to social media, and the problem is that if she can do all that, she can then possibly formulate a falsehood. And this is not a person who, under this record, is particularly adept at telling the truth all the time, and that's the problem.
At this point, we're over time, so if there's no further questions.
Thank you for your questions.
Thank you. Counsel.
Good morning, Your Honors. May it please the Court. Mallory Skrull of the Middlesex District Attorney's Office on behalf of the Commonwealth. I'd like to start with the issue of the civil coercive contempt here. The sentencing judge did properly deny the defendant jail credit for the time that he spent in custody while held in civil coercive contempt. And I'd like to start out by pointing out, this court has considered fact patterns that are incredibly similar to that in this case. So specifically in Ray, the matter of grand jury investigation cited in the Commonwealth's brief from 2017 before this court, like I said, the facts are almost exactly the same. The defendant was lawfully ordered to enter his PIN into his phone through a search warrant and a lawful court order. He refused to do so. The Commonwealth filed a motion for civil contempt, which was allowed after a hearing in which the defendant was present and defense counsel participated. The court held that the petitioner here would be held in civil contempt until such time as he purged that contempt by entering the phone PIN number. And again, this court held that the judge did not abuse her discretion by finding the defendant, the petitioner, in civil contempt or by committing him until such time as he cured the contempt. So I would suggest that this court has outright disagreed and rejected the defendant's argument that civil contempt was an improper procedure or an unheard of procedure in a case such as this.
What about, so procedurally in this case, though, it's a little tricky in the sense that the Commonwealth filed a motion seeking contempt under, and it cited Rule 43, right, the criminal procedure.
Yes.
And the judge allowed it, this is I think on June 3rd, right?
Yes.
And then issued findings of her own, dated June 13th, and she adopted and said under Rule 43. But then when they came back for their status date a month later, again, when it was raised again by new defense counsel, that's when the judge said, and I think the Commonwealth then said, oh yeah, I think I might have mistaken, I think she sort of acknowledged that she intended to seek civil contempt. So what do we do with that?
I think that's a fair reading based on the papers alone, but looking back at the transcript of these hearings, it's clear from the Commonwealth filed its motion for contempt citing the criminal rules on June 3rd. The court held a hearing on June 3rd at which the court and the Commonwealth corrected that record and said this is a motion for civil contempt. So from the date that motion was filed, everyone was on notice and everyone was operating under the assumption that this was a civil contempt order. I believe the June 13th order of the court, as you said, referenced civil and criminal contempt, and there was some back and forth about that. The court did acknowledge at a later hearing that they had maybe pulled some language directly from the Commonwealth's initial motion, but again, on the record, corrected that, understanding that we are operating in civil contempt here. So for the defendant to say that, it was unclear or that he wasn't on notice that this was civil contempt, I would direct the court to the Commonwealth's brief at page 26 in the footnote, where it's clear that the defendant was warned at least, I believe, 7 or 8 times on different occasions for months, almost every 2 weeks for a period of time, that this was civil contempt. He held the keys to his own jail cell. Once he complied with that civil contempt order, produced his phone PIN, the contempt would be cured. I also wanted to just point out that the Commonwealth completely agrees with what seems to be some of the court's questions here about the policy issues at stake. The key consideration when we talk about awarding jail credit is fairness, both to the defendant. We want to make sure that they are given time served for all time that was properly served for this offense specifically, but we also don't want to allow them to bank time or get kind of double credit for that time. So we've seen in Maldonado and Pearson, both before this court, that the defendant can't be allowed to bank that time. If we were to allow the defendant's argument here that he should be given jail credit for the time, several months, that he was held in civil contempt for failure to comply with the court's order, there is no way for the court to coerce a defendant who is in custody for another reason. There is no way for the court to coerce compliance with a lawful court order.
Do you think a judge has the discretion to, like after, at sentencing, to give credit for that time that the defendant was held in civil contempt? I understand your argument that the judge wasn't required to, but.
I think that's an interesting question. My understanding would be that there could be a circumstance where a judge could exercise their discretion. We know that awarding jail credit is a bit of a discretionary issue. Here, Justice Deacon, did a really great job, I feel, in his sentencing hearing. Pages and pages of transcript about the explanation for why he reached the sentence and awarded the jail credit that he did. So he was very explicit that this defendant was awarded jail credit for the time between his arrest and the time he was initially held in coercive contempt, February 19th through June 3rd of 2022, and then again from the time in which the verdict entered on June 30th and to the time at which sentence was imposed on July 24th of 2023. So I agree that there might be a discretionary component, but here the record is very clear as to what the court chose to do in that circumstance. If there are no further questions on the contempt issue, I would move to the issue of the excited utterance, the Snapchat video. So again, the trial judge properly exercised his discretion in admitting the Snapchat, both the video and those banner text messages that were discussed. When we review a written statement as an excited utterance, the analysis is almost the same, almost exactly the same as when we review for an oral statement. The only difference is that we are more closely looking at the spontaneity component. So here the victim was, as this court seems to have realized, clearly under the influence of that startling, that stressful event. She had just been sexually assaulted by the defendant. She had been hit in the face during that sexual assault by the defendant. She records this video of herself. The demeanor, her demeanor in this video, she is clearly excited. She is crying. She is whispering. She is bleeding from her lip. Her statement was made at the same location and in very close temporal proximity to that startling or exciting event. She was still in the defendant's basement. And again, it was made very shortly after that second sexual encounter, the first sexual assault of the day. The defendant was still present in the home at the time this was made. As I believe Justice Tan pointed out, you can hear what appears to be, or what we could infer to be, the defendant moving just outside of the camera, which, again.
But Judge Deacon had some concerns about this, in that the victim testified that when she chose the words to type in the banners, she altered them, that is her word, so that her friend she was typing to, that the DCF group home where she was staying, would not know. How do we get around the fact that she's basically admitted she had the opportunity to fabricate? And that's sort of the opposite of what or it is the opposite of what the standard for excited utterance requires.
So, Your Honor, I would respectfully push back a little bit and say that that's not exactly a fabrication. This court has held in at least two cases that are again cited in the Commonwealth's brief, both Figueroa of 2011 and Joyner of 2002, that One, the motive of a defendant to lie or fabricate is a credibility issue. So even if, and this issue was heavily litigated both in motion practice before the court before being admitted, and then the defendant called an expert in Snapchat technology, the victim testified ad nauseum about the creation of the Snapchat, the circumstances surrounding it. So that issue of the credibility, the validity of that message was an issue for the jury to weigh. We also know, as I mentioned from Figueroa at 79 Appeals Court, page 389 from 2011, that downplaying the severity of an event itself or the emotion involved doesn't mean that the declarant was no longer under the influence of that event. And again, that would go to a credibility issue for the jury rather than, as here, Judge Deacon's discretion to admit the statement in the first place for the jury's for the jury to evaluate. If there are no further questions on the excited utterance issue, I will just briefly address the defendant's third argument here and say that the trial judge did properly deny the defendant's two motions for a directed finding of not guilty because there was sufficient evidence that the convictions were based on the defendant's or the victim's testimony, which the jury credited. The SJC has long held since at least 1978 that the fact that a victim's testimony was inconsistent or contradictory doesn't render that evidence insufficient. It only means that the jury then has to weigh the credibility of those statements. It does not mean that they are not probative evidence or evidence at all, only that that is a question for the jury. So if there are no further questions, I would ask that this court affirm the judgments of the court below. Thank you.
Thank you. Thank you to both parties. The matter is submitted. So we'll move on to the third case on the list, Department of Children and Families versus Mother and Others. Docket number 25P, 250. And again, I'll remind the parties about the impounded nature of the case. And I'll also just mention, because of the number of parties involved on the appellee side, they're sharing their time. When everyone is settled, we can begin.
Thank you, Your Honor. Good morning. May it please the court, Attorney Deborah Dow, and I represent the mother in this appeal who is watching on the YouTube live stream today. Mother was afraid. She was afraid of her child being sent to Brazil, a faraway country with a man who was deported because he had abused her. She was afraid of sending her child to a man who had abused his children, and she was afraid of sending her child to a man who did not even know his child. No one was going to have eyes on this child once he got to Brazil, and he was court-ordered to be removed from essentially the only home he ever knew, living with his grandparents and his sister, and moved to Brazil against his wishes. The judge in this case failed to address the underlying risk to the child in sending him to Brazil. The judge had an obligation to independently assess the best interests of the child. She failed to do so. I would suggest to this court that there are numerous errors of law and that the judge abused her discretion. The domestic violence in this case was not stale. His criminal proceedings, father's criminal proceedings in the Commonwealth, left him in default with a warrant, in warrant status.
Well, he was deported, right? So he couldn't come back. In fact, he tried to appear by Zoom, but the district court, I think, wouldn't allow him to remove his default or appear virtually, right? So that's why he was in warrant status.
Correct. The underlying criminal proceedings were still in existence and certainly were not dismissed.
Right. I don't
And-
think anyone's challenging that, right?
I don't know, I mean, I got the sense, frankly, that counsel for the other parties were contesting that, or were suggesting that, sort of falling in line with what the judge was suggesting and explaining away the underlying criminal proceedings, as opposed to comparing it to the procedure, and saying, well, he just sort of fell, outside of the procedure because we were beyond COVID. And so the judge really explained away the underlying criminal issues.
Well, did she explain it away, or was she just stating the fact that he, like, procedurally, factually, he was deported and he couldn't come back in to the country physically, right, to answer in person to the, to,
Well,
to
Sorry, Your Honor.
remove the warrant?
So not only did she take, I think, 9 findings and 1 conclusion to do that, but she also, in numerous findings, domestic violence was stale. There's no evidence to suggest that.
Didn't she make a finding, though, that she credited, and this is on Record Appendix 42, finding 32, that she says the court credits the father's version of events with respect to the incident in which the mother, that happened in the car, in which she called the police, right?
And that was the only incident, interestingly, where there is independent corroboration. There's a mother called the police came, there were photos taken of the bites that she endured. The Commonwealth, and the case then went to the Commonwealth for prosecution, and as of trial, the Commonwealth stood ready to prosecute. But there were certainly other domestic...
Right, but just going back to that, the judge credited the fathers.
She did.
Right, and so-
She did, and that was the only domestic violence incident that she credited the father and did not discredit the mother. I mean, there were numerous domestic violence incidents. Jamming a cigarette pack down the mother's throat while she was pregnant. Again, judge did not discredit the mother. Giving her a fat lip in the process, throwing cold water on the mother's oldest child to make her stop crying, and again, to make her move out of the bed when she was sleeping with the mother. The father choking the mother, force-feeding this child in particular, slapping his other child in the head, threatening his sons with a sandal. None of those issues were discredited. And yet, the judge consistently found that the domestic violence was stale. And again, not simply because the domestic violence was not stale, but I think it's important to note that the father participated in no remedial measures to improve himself in that regard, despite even DCF suggesting that.
But the father had since gotten into another relationship, and there was information that the judge had that there was no domestic violence concerns in that relationship. So that accounts for no current information current information that domestic violence was not a problem.
The father's carry was not attached to the international home study. So there was no indication other than counsel articulating that father actually had not gotten into any trouble in Brazil. So that piece was certainly missing. In addition to that, while a Brazilian carry seemed to have been run for the girlfriend, there's no identifying information on that particular carry, and that's in the exhibits. Her birth date isn't even noted, so all it says is her name. That's it. So the information on that, I would suggest, was an error of law for the judge to suggest that there was no carry or no incidents between the father and the girlfriend when there was no evidence to support that. Mother also argues that there certainly were concrete facts to support unfitness in this case. The father was unable to care for himself due to having no fixed income and could not even support his oldest 2 children here in the United States. He was unable to care for himself. He had perforated an eardrum because he did not or would not seek out medical attention.
Didn't the judge find, and this is finding 44 on Record Appendix 43, that he owns a snack store?
He did. He did.
At the time of
at the time of the hearing. Right. And while his, there was some suggestion that his income had improved, there was nothing to support that as to what income he had. And the issue of having a fixed income and still continuing to work 6 days a week, so that was questionable as to what kind of relationship he would be able to establish and to maintain with this child if this child were to move. This child would just be moving and be supervised by father's mother, by the paternal grandmother. In fact, the report itself that father submitted at the time of trial actually states that it would be more favorable for the child and in the child's best interest to not disrupt his culture, his language, and not in the child's best interest to break the ties with the grandparents and all of his siblings here in the United States, and mother. Specifically, there was a notation as to mother. And that in the end, even that reporter found that he should be raised in the United States.
Well, that would be ideal. But if the father could not come back to the United States, didn't the resolution of this case ultimately fashion a situation where the boy would still have ties to all the rest of the family?
I think those ties were minimal, and I think that, again, the issue was addressing the underlying safety risks. To continue on, even there were people in the household that weren't even identified or carried. There was a paternal uncle and a paternal grandfather. No information on them whatsoever. No background information, no information as to what kind of contact they would have with this particular child. Certainly, the court should have maintained oversight, at least for a period of time, to ensure the success of this child in a new country, in a new language, and in an unknown household, where household members weren't even identified.
But how does the court do that if there's a trial and the judge finds that the evidence doesn't, demonstrate by clear and convincing evidence of the father's unfitness? Isn't a parent, after that, the parent, why do we keep... Well, at that point, right, doesn't a parent have the right to have their children back if they have not been shown to be unfit?
Well, interestingly, the court couldn't dismiss the case, Your Honor, because the father didn't have underlying custody. So would it have been a stretch for the juvenile court judge to keep that case open and with oversight and with status reviews to ensure the safety and the well-being of that child? It absolutely would not have been a stretch to do that.
Right, but once evidence is shown, right, and the judge finds that there has not been a showing of unfitness, the parent gets their child back, right?
I'm sorry.
Doesn't the father then, sure, maybe in this case I understand with the underlying custody that the case actually does remain open and there is monitoring, but absent that.
Well, absent that, but that's not the circumstances of this case. This case in particular, the father did not have underlying custody, and certainly this
so the
judge...
case is still open until he
certainly because of the nature of the circumstances and the abrupt moving of this child, and certainly against his wishes, where there still are unknown safety issues, including a lack of background checks on some of the people that would have access to this child and in the child's household, the court should have kept this open and had status reviews.
And I guess, can you just explain, what do you mean when you say the court should have kept it open? I mean, they had a trial, the
Right.
judge had a trial.
And the
and
court-
then made the finding that she did, and then the child is reunified with the father. So what is that, what do you mean by kept it open, I guess? Because the case does remain open, given the fact that he doesn't have underlying custody.
Right,
So I
right.
guess I'm not quite understanding what you mean.
So
by-
I think the other piece is that I don't think it's unusual in these cases to have the judge where there's an interstate compact, and here this is an international compact, to maintain the case open, at least for a period of time, before a dismissal occurs, to ensure that there are no outstanding safety issues or concerns with respect to the child.
But practically, that's what happened here, right? The case is still open.
Right, but there was no oversight by the juvenile court. So no further status. In fact, she made a specific ruling that any further issues needed to go to probate court. So the juvenile court essentially washed their hands of this case after the judge's ruling. The best interest of the child, again, I think looking at the issues of ensuring that there's a stable home, ensuring that there's financial capabilities, safety, how this is going to affect the child's unity with his family, and in particular, the father's ability to meet the child's physical and emotional needs. Child went for a week-long extended visit, came back, and according to counsel for the child, was even more resolved than ever that he would not want to go to Brazil. The mother also argues ineffective assistance of counsel for the child pursuant to Safarian as well as care and protection of Stephen.
How do you square that? I'm sorry, go ahead.
Does the mother have standing to do that?
I think the mother does have standing, and I argue that in my reply brief when the issue was raised for the first time. So I don't believe, so the Commonwealth versus Adamites, there is a fact basis for the claim that it appears indisputably on the record. So in other words, what mother is arguing here is that she was certainly harmed, and the child was harmed by counsel's failure to bring the case forward and to prosecute the case in accordance with not just CPCS standards, but professional conduct standards as well. In addition to that, the contested issue of the attorney's ineffective assistance is clear on the record. He admittedly and did not go forward or prosecute the case despite his child client's clear preference. And that is the Zinsser and the McCormick cases as well. So I certainly think the mother has standing to argue that.
What about adoption of Mary?
I'm sorry?
What about adoption of Mary, which is cited, I know, by the opposing counsel, in which the SJC in that case said the mother, I believe it was the mother in that case, didn't have standing to challenge the trial strategy of the child's attorney.
Right, and I understand that that there is conflicting case law from what I'm suggesting, but at the same time, who's going to argue this on behalf of the child? I mean, I think at some point there has to be a pragmatic look at who is able to have standing to argue that. So not only was child affected, but mother was affected, the other sibling was affected, as well as father's two children here.
You're saying in a case where the client is, let's say, under a disability or guardianship, something like that, then you're saying there's a risk that nobody can raise an ineffective assistance of counsel claim, and so anybody else in the case can raise it?
I think in this particular case, where there's a 5-year-old and little to no expectation that a 5-year-old would then be able to turn around and raise ineffective assistance. So yes, in this particular case, I would suggest that that would be the case.
How about appellate counsel for that same client. It could be raised in that way, right?
Potentially. But again, I think there's an issue of, is it pragmatic to think that counsel would necessarily fall on the sword for another party? So I would suggest that mom does have standing on this particular issue.
Okay, I'm sorry, we are over time, but I'll let you finish if,
If there's nothing further, then I would rest on my brief.
thank you.
Thank you.
May it please the court, my name is Carol Frizzoli, and I represent the Department of Children and Families. The trial court rightfully awarded permanent custody of this child to father in Brazil after a successful international home study was completed. The child withdrew his objection to being placed with the father, and the child was successfully relocated to Brazil with a visitation agreement allowing child to keep in contact with his maternal grandparents and sister. There was no abuse of discretion. In the first instance, the mother in this case has no standing with respect to the first issue. Certainly, the trial court noted in its findings that in adoption of Paula, first of all, mother is not an aggrieved party here. This was a permanent custody hearing. Mother stipulated to her unfitness prior to the proceeding.
To her unavailability.
Her unavailability, unfitness, which has been deemed as, it's the same definition. But yes, mother stipulated to her unavailability in this case. She was not seeking custody. However, she wanted to put evidence that father was unfit. The court, in citing and questioning whether that this could even be done, cited adoption of Paula, which cites to a non-published decision of adoption, I believe it's Henry. Anyways, that the father...
I think it's the unpublished case cites.
Cites, correct. And adoption of Paula, basically, in that case, they said the father doesn't have standing. In this case, the mother doesn't have standing to challenge fathers.
That case was a little bit more subtle. They didn't really talk about standing. They just said, we're not going to address those arguments.
Right. So, and again, if you look at, I think it's Care and Protection of Benjamin, which was cited in the reply brief, that allows a party, when the department withdraws or doesn't prosecute a case in a care and protection, another party can stand in their shoes. Understandable that, so I think with that, I think the judge was appropriate in allowing mother to put evidence forward about father's unfitness. But here we are at appeal. Mother is not an aggrieved party in this case. Now, this is a permanent custody case. Mother has many options. Her rights have not been terminated. Although the court did say in the judgment that mother could go, that the case should go to the probate matter, which I believe, although father might have not had underlying custody in the probate court, the couple was, it's in the findings, the couple was divorced, and I think father's counsel will speak to that more about the ancillary proceeding in the probate court, which gave father underlying custody as well as.
So I'm sorry, so you're saying that, you're acknowledging that the mother did have a right to prosecute, present evidence at the trial, but now she can't appeal the...
Well, again, where is she the aggrieved party? She's challenging father's, if you look at the adoption of Paula, she's challenging father's unfitness. She's not, it's that the judge should have not found him fit. That's essentially what she's challenging here. And as Your Honor pointed out earlier, the judge found that, so even if you argue that she had standing in the underlying case, this appeal, I mean, there's no remedy here for the mother. I mean, the remedy is to go, if she's challenging father's, she can go to the probate court and challenge, and she could ask for visitation. She could file a review and redetermination in the juvenile court.
Let's just say, and I don't know if this will be the case, but let's just say that there was, the trial was rife with reversible error, let's say. So then the mother who you're conceding has standing at trial, then again, are we supposed to just ignore, like then she can't
No, I'm just saying, my argument is she's not an aggrieved party. Whether your honors agree with that, I mean, in order to have standing for an appeal, and again, standing is not an issue that's ever waived, it's jurisdictional. So in this appeal, essentially, mother is requesting, I believe in her prayers for release, she wants the child, they fathered the child to return from Brazil or, to remand, to have another hearing about father's fitness. But again, in this case, the child is in Brazil. If mother wants to challenge that, she has remedies and the lower courts. She could file a review and redetermination. She could ask for visitation. She has remedies. And in this court, what remedy you could reverse, I assume, and say, mother has, that the court erred in finding father fit. Father was fit. So she is contesting father's unfitness. And that's why I'm saying, our argument is that she's not an aggrieved party here at the appeal stage.
Didn't the judge have to do more to resolve the question of whether there was domestic violence under all those cases like custody of Vaughn?
Well, and I think the judge did, because I do want to point out, the judge listened to the testimony, and it was only mother's testimony. There was nothing that was corroborated, and the only documented incident of domestic violence in this case had to do with the incident that resulted in father's deportation. Mother ended up, the attorney in that case recanted, but the trial judge did make credibility determinations about those domestic violence things.
Actually, though, I mean, so the findings, 26, 27, and 28, and 29 on Record Appendix 42, the judge discusses those incidents of mother's testimony about the various domestic violence incidents, and then she ends each finding with, the court finds that mother believes this incident occurred, but the court declines to make a finding on the veracity of her belief. What does that mean?
That means
Does that mean, she doesn't say, I discredit the mother.
No.
She says, I decline to make a finding on the veracity of her belief. So is she kind of just saying, I'm not either crediting or discrediting, right? Is that
No, I
is that
think
a
what
fair
she's
reading?
saying is that that the mother believes these incidents happened, but she does not believe, the judge does not believe these incidents happened, but
it
credits
says-
that the mother does. I think she's actually saying, I don't believe it's credible.
But why didn't, it says the court declines to make a finding on the veracity of her belief. She could have said, I discredit the mother, or I don't believe the mother, or.
Again, the
right?
wording she used, she could have used better wording, but clearly she definitely, again, these were all, there's no, she didn't find mothers, she found that all of these incidents, and what, even if she didn't find that those incidents were credible, what's noteworthy is she does say that all of these incidents are stale, and that father did engage in a nurturing father program out in Brazil and was still, so he addressed any issues that came into play with respect to this care and protection through his services. So, as I see my time's up, the one I did want to say one comment about the mother doesn't have standing with respect to challenging child's and ineffective assistance counsel, and I think that's set forth in our brief and supported by adoption of Mary.
Thank you, thank you.
I have no further.
Good morning, Chief Presiding Judge for today, Singh, Judge Grant, and Judge Tan. I am Deborah Sirotkin Butler, representing Father as appellee, as I did at the time of his first trial, as I did at the time of adoption of Addie, as I continued to do at the second trial, as I do in the probate court, and as I do before your honors. So if there are questions about those things, I was and remain his attorney.
Can I ask you to comment on the judge's findings with respect to the domestic violence incidents in which she says she declines to make a finding on the veracity of the mother's belief. What is,
I do
what
not
you think
know.
Does that, can we,
What I look to, Your Honor, is the finding of law number 25, in which the judge discusses the Vaughn case and the Lilith case, and finds and summarizes why it's in this child's best interest to be in this father. Further, the father was in the United States for 15 years. He had a prior relationship with 2 older children and another mother. There is absolutely no other carry issue or record of father being aggressive or violent with anybody. On the other hand, the judge in her findings goes into the 6 open criminal cases against mother, which in 2024, there was an assault and battery, there was felony witness intimidation, 2 open 209As, and 2 harassment orders. The judge also heard the first trial, which was a 4-day trial. And this court does have that record from the case that became adoption of Addie, and of course, I was present for that testimony. The judge, rather than further going into it, focused on the fact that father provided 20 exhibits concerning his fitness, that father has a retained master's level social worker, Bruna de Brum Cabral, in Brazil, who has visited the family and with whom he counsels weekly. She quotes Ms. de Brum Cabral repeatedly. That CV is in the record. Ms. Cabral is an acknowledged expert at the Hague Court. She teaches classes in domestic violence and is a governmental figure in providing services to children, and she continues an involvement with the family. In addition, the judge looks at the best interest of the child. The child has been there for 11 months, and it's my understanding that current appellate counsel has had virtual meetings with that child, which he can speak to. I was not present at those. Father was removed from the United States, not because of mother's allegations, although they may have put him back on the map, but because there was a prior deportation order, there was a presidential policy, and once he was noticed, he was in fact deported. He was deported before I could meet with him physically. He was moved rapidly from Lowell to Maine to Louisiana to Brazil, and I located him in Brazil. And I wish every client stayed in touch with me like this man does. He continued to have monthly meetings with the social worker throughout the case. He attended every single session of the Nurturing Fathers program, as described in the record, and maintains a mentoring relationship with the leader. He has had the same attorney for 5 years. If you look at the docket sheets, I'm kind of lost track whether mother has had 7 or 8 attorneys. But you can find that in the docket
excuse me,
sheets.
on the domestic violence issue, my concern is that the judge kept saying that if the domestic violence allegations were true, they were stale. And it doesn't seem like a very long period of time for staleness to happen. Why couldn't the judge have just said, even assuming that there was violence in the relationship, I find that given the father's adjustment in Brazil and the lack of problems in his other relationships and his commitment to this case and the mother's other problems, I find that they do not pose a credible problem under whatever the language is in Vaughn.
I can't speak to why she chose the words she did, Your Honor. I wish I could. Just as I can't speak to why she left the juvenile court bench and went to the district court bench. I think that there may be similar reasons for those two circumstances. What I can say is that my client completely engaged with me, with DCF, with the Nurturing Fathers program, that his record while he was in the United States for 15 years, paying taxes, running a business, supporting two families, the only blip, the only one, is our mother's allegations. And in addition, his first criminal attorney provided an affidavit that mother had recanted. His second criminal attorney provided a lengthy affidavit of his diligent, lengthy efforts to clear his name, which is part of the record. That's Attorney Eileen Morrison.
Counsel, I'm just going to, we're over time now, so
I apologize, Your Honor. If you have any further questions, I'm happy to honor them. Otherwise, I rest on my brief and the record of the evidence we submitted.
Thank you.
Good morning, Your Honors. May it please the Court, Peter Heffernan on behalf of the child. Your Honor, we're asking the Court to affirm the order of the juvenile court finding father fit to parent child. I think this case is a difficult case in terms of its impact on the parties and the family, but in terms of the legal case here, I think it is a very straightforward and uncomplex case. The only party at trial seeking to prove father's unfitness was mother, and she failed to do so.
Can you speak to the mother's attorney's argument that the child's counsel should have put on evidence or challenged the father's unfitness because he wanted to stay, or he expressed a desire to stay where he was and not go to Brazil?
Yes, and I think child's counsel was very clear with the court regarding where child was at with what was happening. And I think this distinguishes this case from the case cited by Mother's Counsel in her appellate brief of Flora, in which they found ineffective assistance of child's counsel, where that attorney concealed information from the court, misrepresented child's position, and aggressively cross-examined mother, all of which were contrary to child's position. Here, counsel clearly was transparent about what child was feeling, but at the same time, there were competing interests. There was one, child going to Brazil. There was also the interest in child maintaining his connections with family here. And I think that under the rules of professional conduct, child's counsel could reasonably have said, I understand this is child's stated position, but it's not an adequately considered position because we stand to gain nothing. And I think child's counsel understood that there was not evidence of father's unfitness, that would have been a fruitless pursuit, whereas he could preserve child's relationship through his agreement for post-adjudication contact with grandparents.
If he has a client who's old enough to state a position, right, even though he was unsure if the evidence would be sufficient to show unfitness, did that attorney have an obligation under?
Well, we are at a bit of a disadvantage here because we don't know what those communications were. We don't know the nuances of those. This is an issue that was not brought before the trial court, as it should have been, at which time there could have been some fact-finding around what was that communication, what was child's. Basically, child's counsel was communicating to the court, well, the child's not excited about this. And who would expect a 5-year-old to be excited about that abrupt of a...
Was there a GAL?
There was no GAL.
So but that could have been an avenue for the judge to figure out what the kid wanted.
It could have been.
So somebody should have raised that. Who should that have been?
I don't believe it should have been raised. The question as to the position the child's counsel was taking at trial?
No child's position.
No one challenged that during the trial. And I see my time is up. If the court has any additional questions, otherwise I would rest on my brief.
Thank you. So at this point, have we heard all the parties in the case? Okay.
Yes, sir.
Thank you. Thank you for all of the parties, all of your arguments. The matter is submitted.
Thank you, Your Honors.
It's up to you. Okay, at this point, the court will be in recess.
All rise, please. Court is now in recess. Rise, please. Court is now in session. Please be seated.
So we're back on record with the case of Sylvia Scott versus Ray Street Properties LLC and another 24P 1393. Counsel.
Good morning, Your Honors. May it please the Court. My name is Jeff Lindequist, and I represent the appellants, the defendants below, Ray Street Properties, LLC, and Mr. David White. The judgment of the trial court is nothing less of the product of a series of compounding procedural and substantive errors that have culminated in a six-figure judgment that is almost completely unsupported by law or evidence. The judgment should be reversed and the matter should be remanded for further proceedings. The principal error, and I believe where the case goes awry, is in the trial court's decision to grant reconsideration and summary judgment on the totality of the case by virtue of that reconsideration. Where this is a departure from, I believe, the law and certainly the rules of procedure is that in the first instance, the motion for summary judgment was only ever aimed at 2 of 4 claims. The motion for reconsideration was then only aimed at a part of 1 claim. The trial judge properly determined that there were issues of material fact for trial, and summary judgment should have been left there and a trial conducted. On reconsideration, the Scotts brought nothing before the court other than a disappointment that it took too long to rule on the motion for summary judgment.
Well, so are you saying that a judge can't reconsider his own ruling on summary judgment unless a party gives him new information?
I don't believe so, Your Honor. I think.
But how can, if a judge, upon further reflection, you know, and here, there had been a year, I think, that had passed, right, between the time that the argument, that the trial court held the hearing and when the first decision was issued. And I know the Scotts had brought to the court's attention that the judge needed to issue findings, and that's when the initial findings were issued, right, which were pretty. So I guess I'm just following up on Justice Grant's question that a trial court judge can't reconsider a decision absent some new information? Because what if a judge, upon, you know, maybe on their own, says, hey, I think maybe I've thought about it more and I don't think I got that right.
Okay, so I think there are a couple things there. And I want to address them all, Your Honor. So first, as I understand the proceedings, I was not involved in the trial court. I've been retained for the appeal. As I understand the proceedings, an inordinately long time elapsed between the argument on summary judgment and the decision. And the decision was, I find genuine issues of material fact for trial. The motion is denied.
And there were no reasons given.
No, there were no reasons
right.
given. I think that.
Which I think is fair for a party, right, to come back and say, Judge, can you tell me why you made the decision that you made? And give more explanation.
I don't know, Your Honor. I mean, often the finding of genuine issues of material fact is in and of itself sufficient to deny a motion for summary judgment. Those denials are often made at argument on the record and not even written. A party could certainly ask for articulation.
Well, yeah, so the judge here at the hearing on the motion for summary judgment said on August 3rd of 2022, the counsel for your client argued that there were genuine disputes of material fact, and the judge said, well, we're going to need an affidavit of Mr. White, and I'm giving you till August 15th, 2022 to file that affidavit. Did that affidavit ever get filed?
I do not believe so, Your Honor. I've not been able to find that in the court record.
So then 10 months later, the judge summarily denies the motion for summary judgment, saying there's genuine disputes of material fact, but there's no affidavit from Mr. White. Why couldn't the judge decide, oh, wait a minute, I forgot, there was supposed to be an affidavit here? And there isn't an affidavit, so maybe the plaintiffs are right that as a matter of law, the Ray Street didn't comply with the notice provisions of the summary process and the warehouse lien statutes.
Yes, to a point, Your Honor. There were two issues, as I found in the summary judgment argument, where the judge said this is a potential issue of fact. One was the issue of whether the postings and conspicuous locations in the communities were actually made. And to that, the judge said, you need an affidavit. And that wasn't, to my knowledge or ability to reconstruct the record, ever done. However, there was another issue that the judge raised with respect to the actual notice of the sale to the plaintiffs. And on that issue of fact, the judge, I believe, was relying upon the deposition testimony of Mr. White that was appended to the original summary judgment motion. And I do believe that the rules permit deposition testimony to be submitted along with interrogatories, admissions. The interrogatories, for instance, I believe also stand for the proposition that we believe that the Scotts had actual notice. So for that issue of fact, I don't believe that an affidavit was required, and no additional countervailing information was supplied in connection with the motion for reconsideration to negate that issue of fact. So I don't believe that it was appropriate here for the court to think harder and determine that, well, there was no affidavit, so that cures all of the factual disputes that I flagged at my hearing. There was at least one, I believe, material fact here, because actual notice may well obviate not obviate the requirement to provide publishing, the technical requirement to provide publishing, but as I noted with respect to the claim that Ray Street failed to solicit changes of address, you typically need to demonstrate not only the technical failure to comply with the statutory requirement, but also a specific harm. And if the Scotts had actual notice of the sale, then
But how do we know the Scotts had actual notice of the sale? You're saying because that's in the deposition testimony?
the deposition testimony, Mr. White testified that he sent notice of the sale date, and that led to a colloquy between the trial court and Mr. Scott, where he said, listen, you know.
But my understanding was that at one point Mr. White was saying that the notice of the sale date was implicit in the Superior Court injunction.
That was the argument that was advanced by counsel. I believe the deposition testimony, and I could certainly, unfortunately, the one note I didn't make this morning, I believe the colloquy was on Record Appendix 1, 237. And my understanding of the summary judgment record was that was a deposition. It said, did you send notice to Mr. Scott? And Mr. White said yes, which led the judge to say, well, did he ever give you a copy? And Mr. Scott said, no, he didn't. Well, okay, well, you may win at trial because you may be able to.
So you want us to assume that did you send notice that Mr. White said in his deposition meant a separate notice, a letter, as opposed to the notice sent by the Superior Court or that initial notice sent in March?
I believe that's how the court treated that testimony, or that, I'm sorry, it wasn't testimony, it was a summary judgment here. That's how the court treated and construed that evidence.
Right, but is
when-
there any evidence in the record that White or anybody from Ray Street represented that the defendant sent to the plaintiffs a notice that the auction would take place on October, I think it's 27th?
That deposition testimony that the judge discussed in finding an issue of fact. But no, that's the evidence, Your Honor. And I think it's material here because when the Scotts asked for reconsideration, they narrowed their arguments to simply the posting. However, they didn't offer any new or additional argument or evidence to negate the genuine issue of material fact that the trial judge found with respect to actual notice. And so even if the reconsideration was proper, which I don't believe it was, that reconsideration should have only led to a decision on the issue presented, which was whether constructive, or I'm sorry, not constructive, but posting was properly made or should have been made. But the Scotts didn't ask the judge to reconsider, as I read the motion, all of the motion for summary judgment. They said, we want to press this one argument. And what was a partial summary judgment in the first instance was an even partialer summary judgment on reconsideration. And so where there was no new information or a manifest error of law was not demonstrated, I don't believe reconsideration should have even been granted, irrespective of the scope.
What do you do with the fact that the summary process statute, as amended after the Evans case, required the warehouser to provide a warehouse receipt by return mail of some sort that states, identifies the publication in which the auction will be advertised?
I don't know what to make of that because it wasn't a particular claim that I think was addressed by the court here. I have a receipt that was provided. I know that there was some reference to it, but as I read the decision, it turned more on whether posting was proper, whether monthly statements were sent, and whether a return, a new address was solicited. I'm sorry, Your Honor.
Do the defendants just get to decide we're not going to publish in the newspaper, we're just going to post? Where the summary process statute says you need to inform the plaintiffs of the publication?
I believe if there's, like anyone, they have to take the statute and determine based on the information they have whether there's a newspaper of general record or a newspaper of record in Holyoke. I won't asperse the Republican. I don't know that that counts as a newspaper of record in any part of Western Massachusetts, although it's widely read. But I think that the warehouser has to make the decision based on the facts, whether there is a newspaper or whether it should be posted. Now here, you know, and perhaps the Scotts might prevail on that claim at trial, but the only evidence that they presented that there was a newspaper of general record was hearsay and shouldn't have been relied upon. It didn't even address whether there was a newspaper of general record, only what its average circulation was. It's their burden on summary judgment to prove every essential element of their claim. It's not on summary judgment for the warehouser to prove that there was no newspaper. That's for trial.
Do you have anything in the record that shows that Ray Street identified the publication?
No, there's one receipt in the record. It's from A to Z Movers, which was the moving company that was engaged by the sheriff. And they issued the moving receipt, which I believe can be adopted by the warehouse. My time is drawing to a close. I think that at any event, the judgment has to be reversed. It's a partial judgment. There's no evidence to support 3 of the 4 claims that were supposedly adjudicated by this motion for summary judgment.
I could imagine a scenario where there might be evidence on summary judgment that the notice provisions were violated, but a defendant might submit an affidavit saying, even though we technically violated the notice provisions, we weren't negligent or in violation of the Consumer Protection Statute because there were extenuating circumstances. It was COVID, or I was in the hospital, or something else happened. But without an affidavit from Mr. White, how can we decide, and why aren't those arguments waived?
Well, so the first question, they didn't move for summary judgment on the negligence claims, and in the motion for reconsideration, they didn't move for reconsideration of the denial of summary judgment on the Chapter 93A claim. I certainly don't think, one, a non-movement has no burden of producing anything until the movement has met its burden. I don't think a non-movement has any obligation to defend a claim that's not being attacked or not being advanced. And that goes into my brief answer on the waiver issue, and that is, you know, we have here a motion that was motion for summary judgment that was limited, a motion for reconsideration that was even further limited, and then a judgment that went far beyond what was ever requested by the plaintiff.
So if the judge had more explicitly considered your, the negligence claim, the judge could have awarded punitive damages. And if the judge had more explicitly considered the 93A claim, the judge could have awarded treble damages. Are you asking us to remand for the judge to do those things?
I think you have to, Your Honor. I mean, the claims weren't adjudicated. You can't enter judgment unless the case is over. And I think that I'm asking you to reverse the entire judgment, because I believe that the judgment that was issued was based on errors of fact and law.
Did you ask Judge Fields to vacate the judgment because all of the claims weren't adjudicated?
No, Your Honor, but at the time that I became involved, they had already issued an execution prematurely. So it didn't seem prudent to await further adjudication in the trial court.
I just don't know how we can decide these issues in the first instance on appeal, or, you know, the 93A demand letter, for example. If that had been raised below, it's possible there might have been something that would constitute a 93A demand letter, or Judge Fields might have ruled on it somehow. I don't know how we can, as a matter of law, decide that in the first instance.
Well, I think it's because he shouldn't have considered it, because he wasn't asked ultimately asked to reconsider his decision on the 93A claim. I think, you know, to Justice Tan's point, I think there are instances where a court might sua sponte say, I made a mistake, but I don't think a court can sua sponte enter summary judgment without a party moving for it.
Okay, so we're over time here.
Your Honors.
Counsel, thank you. Mr. Scott?
Good morning, Your Honors. Justice Grant, Justice Singh, and Justice Tan. What I will get to in this case very clearly, I'll go to the most heart of it. The reason the summary judgment was requested in the lower court is because Ray Street had 2 options during the auction under the law. The first option is to put it in the newspaper and follow the law on that according to Chapter 106, Section 7-210, which goes into a lot of detail. The other option is to, if there's no newspaper, to post it in the area. The problem here is Mr. White, under his own testimony in interrogatories and with the deposition, made it very clear he did not put it in the newspaper. His answer was he used an alternative method. The method he used was he said he posted it in 6 locations. The problem with that was, at that time, we went to the court and the judge gave us an order where we could question each one of the witnesses who claimed, the businesses who said they were going to post it. Mr. White's attorney provided all those sworn statements, and every one of those statements, nobody swore that they posted it. So I don't have to prove in that case that he had to have 6. I only got to prove he didn't meet the 6, which he didn't do. So our position is, for his liability, he's liable. He cannot overcome that. He has to overcome liability first before he can get to all the other issues. Because Chapter 239, Section 4 is very clear. It makes it very clear that to have a valid lien, you have to comply with these sections of the law. And he did not do that. It was not just one item, it was many things he did that he violated the law on. And that was the result of getting a filing for a summary judgment, because the purpose of a summary judgment is to see are there any issues for trial. Since he was already liable because he can overcome that by violating the law, we didn't see no sense that it had to be a trial, because that's the key issue there. The key issue was he had to make sure he wasn't going to be liable. And then all the other issues came in. One of the things that he mentioned that I would bring up, in the beginning when they take the property to the warehouse, they're supposed to send a return receipt. That's what the law requires. And there's a reason for that, because if a tenant says that he did not get no information about that, the warehouse has a receipt to verify that he sent it out and they signed for it, and it's proof, a document. The same thing is required before an auction. You have to send out something, the law says, by receipt mail. You have to send it out, and it has to be signed. In this case, during the discovery, Mr. White had made many claims that he sent out letters here and there, and we required them in discovery. We counted 23 letters he said he sent out. Not one was produced in evidence, not one. Out of all 23, none of those letters was ever produced by his attorney. They were put into the evidence. They're not even in the files. And so our position is that he's just not been truthful. And one of the things you have in the record is that the judge even warned him at one time because he was being misleading in the discovery process about giving us documents. And I found that the documents were available, and I produced them for the court and brought to the court attention, because I had filed a motion one time back in this case to get for sanctions because he was not complying with it. The other thing is the biggest thing is here too is the conversion, because the law says in 106(7) that if you fail to comply with any of these sections, you are guilty of conversion. And it also says in Chapter 239 about the Chapter 93A, which I want to address that for a minute. In our original claims, we did raise the Chapter 93A claim, because it says if it's in Section 4 of 239, if you violate any of those sections, it's also a violation of Chapter 93A. Now, the argument being made that I didn't send out a 30-day demand letter to raise that issue was because the law ties up our hands. If any issues against a warehouse, you have to go back to the court, which heard the summary process case. My understanding is if I would have done a 30-day demand letter, then that would have given me the right to file in any court. That's the purpose of using the demand letter for Chapter 93A. It can be filed in district court, superior court, any court. Because this was in the housing court, I was limited to go to the housing court. I couldn't go anywhere else. So it was my understanding the way the summary process case works, the Chapter 93A was embedded in that system like it would be for tenants when they're going through an eviction. So I just did not do that because I didn't think that was proper, because it didn't going to give me the same freedom if I would have done it in any other court. I'm willing to answer any questions. Do you have any questions for me?
What do you have to say in response to the Ray Street's argument that Judge Fields improperly considered your testimony on the value of the vinyl records?
Oh, I disagree with that. What he did was, in that case, he took my life experience. During that damages phase, I testified that I used to sell records, and I'm a record collector, my own person. So I didn't give expert testimony. I gave to the opinion and the value of my own property that I no longer had in possession. I've been collecting records since I was, I guess 10 years old. Beatles, definitely the Beatles records, things like that. So, and autographs, baseball things, I've been doing that for a long, long time. So it's just based on my own life experience.
Any other questions?
No.
All right. I think we have it.
Okay.
You have more time if you'd like to, if there's anything else you'd like to say or you'd like to just close.
I just want to say one thing before I leave. I just want to say I don't believe that the case should be reversed because I don't believe Ray Street can overcome liability. Liability is key here. This is, to me, it's a narrow issue. It's whether or not they have the right to sell the property. That's really the issue. The other things like the building and all that, those are small things in the law. But the key and most central issue is, did they comply with the notice that's required under the law and the advertising and all that, or did they comply with the law and the postings? And the answer to both of those is no. Definitely the newspaper is not even an issue because he said he made it clear in his own sworn testimony that he did not do that. So I just don't think I think the court should upheld the judge's decision.
Thank you.
Thank you.
Thank you very much to the parties. This matter is submitted. And at this point, we are at the close of all of the cases that are...
The first one.
Oh, I'm sorry. We do have another case. That is Commonwealth versus RUBEN, SEMEDO, BRAUN, 25P 285.
Good morning, maybe it's good afternoon at this point. May it please the court, Edward Crane on behalf of RUBEN, SEMEDO, BRAUN. The first issue in this case is whether the defendant was subject to custodial interrogation at the time of his incriminating statements. The groom factors support a conclusion that the defendant was in custody. The first factor, the location of the interrogation, supports the conclusion of custody because the circumstances were moderately coercive. The officers ordered the defendant and his companions to exit a private residence and line up outside. The officers then frisked each individual, ran warrant checks on them, and forced them to wait outside in the freezing cold while a canine dog was used to search the residence. From the defendant's perspective, these circumstances would have been moderately coercive. The second groom factor asks whether the police conveyed to the person being questioned any opinion or belief that the person was a suspect in the investigation. This factor also supports a conclusion of custody. Detective Almeida asked Sergeant McDermott if he should call the state police to conduct gunshot residue testing on the detained individuals. This statement made it clear to the defendant that the police believed him and his companions to be suspects in the investigation. The third groom factor is the nature of the interrogation, and the defendant would concede that this factor does not support a conclusion of custody because the questioning was not aggressive. The final groom factor asks whether the defendant was free to leave, and it is unquestioned that the defendant was not free to leave at the time that he made the statements. Thus, 3 out of the 4 groom factors support a conclusion of custody, and thus the court should conclude that the defendant was in custody at the time of the questioning. Turning to the issue of interrogation, I think it's fairly straightforward that the defendant was subject to express questioning. He was asked, who said that? That's
Okay, at what point? So if you could walk through, at what point was the first piece of interrogation?
Who said that? When Detective
So everything that was said before, that was said by the defendant before the officer made the comment, who said that, you don't challenge that coming in?
I don't challenge that coming in.
And what were those statements?
Those statements were, you don't have to, it is mine.
Okay.
So the Detective Almeida asked Sergeant McDermott if they should call the state police to conduct gunshot residue testing. That's when the defendant makes a spontaneous admission, you don't have to, it's mine. But Detective Almeida doesn't know who made the statement amongst the group, turns to them and said, who said that? That's the beginning of questioning.
Does it matter that it's said to the group rather than this individual?
I don't think so. I think that they're all essentially.
If it's said to a group, is there really any compulsion on any particular person responding?
Well, it depends on the situation that they're in, and I think, as described, I think that they're all in a coercive environment, and that they've all been ordered out of this residence, ordered to line up.
An officer is saying to a group of people who said that, there's nothing about that that compels this particular person to say, oh, I'm the one who said that. The others remain quiet.
Well, I think ultimately the question, though, is when we look at whether this constitutes questioning for purposes of Miranda, is it questioning? Is it express questioning, number one? And I think this falls into, you don't even have to consider whether this is reasonably likely to elicit an incriminating response. It is questioning. It's express questioning.
Let me ask you, does anything after the initial statement really matter in this case? The admission that this is the gun's mine.
I think so, and that's because the initial statement is evidence clearly, but they don't know who's made the statement at that point. So if the only piece of evidence that's admitted at trial was just Detective Almeida's testimony, someone in the group said that it was mine, I turned to them, and then that's it, because everything after that was inadmissible. Then the Commonwealth doesn't, that's not a slam dunk case for the Commonwealth. I would say it's not even, it's very, I would say the admission of the statements made after are not harmless beyond a reasonable doubt. Again,
so how about if we do not agree with you that the statement, who said that to the entire group, was interrogation of the defendant? Where do you go next?
If it's not interrogation, then I lose on that argument. But I don't see how it couldn't be interrogation in that it's a question. It's express questioning, and I haven't read any case that says because the questioning is to a group that's in custody.
What if the officer had said, who said that? And the 8 other people said, I didn't say it, I didn't say it, I didn't say it, and your client remains silent. Would that be custodial interrogation?
I still think that asking the question is custodial interrogation. I guess, is the question, could they admit his silence?
Could they admit the other 8 people's statements that they didn't say it? Here's another way of getting at the same issue. Is the fact that your client may have felt that he wanted to own up to having the gun to let the other 8 people off the hook of being dealt with by the police, is that one of the groom factors?
The fact that he wanted to let
his apparent impulse to not have his friends subjected to police interrogation, is that part of the groom analysis?
I don't believe so. I don't see where it would fit into because I think that the groom factors don't look into the content of the statement itself. They look into really the situation and the atmosphere, and they look into the content of the questioning and the tone of it. but I don't think that they look at the statement that's made in making the assessment of custody.
Well, as you say, the purpose is to try to figure out the atmosphere,
Yes.
right? And maybe part of the atmosphere is not being brought about by the police necessarily, but being brought about by his friends, his community. So the compulsion is coming from a different source, internal compulsion.
I mean, I understand that's a possibility, though, but we also don't have anything on the record that says that he's doing this to help out his friends. I mean, I think that...
Could the judge have seen it that way, based on what was presented?
I guess, but I guess stepping back a step, I don't see how that fact that he may have been doing this to help out his companions, how that impacts whether or how that is relevant to whether he was in a coercive atmosphere or not. I mean, ultimately, this comes down to, he's got the constitutional right not to incriminate himself, and he's in a coercive atmosphere, and he hasn't been advised about that right, and at no point is he advised about it. At no point does he waive it. So ultimately, I mean, it's a constitutional question, and of course, the fact that he makes a confession is it's powerful evidence of his guilt, but ultimately...
It's not just the only piece of evidence that the government has against your client, right? Their case doesn't rise and fall just on his admission. They also have evidence of your client's fingerprint on the magazine that's found inside the gun, as well as the fact that he had come out, there was a separation in the garage with a curtain, right? And,
yes.
And that the bed was behind the curtain. He was one of the only people seen in that area when the police came, right?
Yes, Your Honor, but I would say that this is, without question, the strongest
Sure.
piece of evidence against my client in this case. And under the standard of harmless beyond a reasonable doubt, it's a stringent standard that the Commonwealth has to meet. And the assessment does not go into, oh, well, taking out these improperly admitted statements, was there sufficient evidence? It's ultimately, how did this weigh into the calculus of proving the defendant's guilt? And again, the fingerprints and the location of the defendant in the apartment, maybe here, but the confession itself is way beyond that in terms of its probative value. So I have a hard time seeing how this could be considered a situation where the admission of these statements was harmless beyond a reasonable doubt.
Could you go through your analysis on the ineffective assistance of counsel claim for failing to file a motion to suppress when there was a consent issue?
Yes. So thank you, Your Honor, for directing me in that location. So the argument is essentially that trial counsel should have made the argument that Andrade's consent to search the garage was tainted by prior illegalities. So had counsel made this argument, the motion to suppress likely would have been successful. So prior to Andrade giving consent, the police unlawfully searched the fenced-in backyard of the residence. They unlawfully entered the residence and ordered everybody to exit. They unlawfully pat-frisked everybody in the residence, and then they unlawfully detained everybody. So I would say that these illegalities tainted Andrade's consent, and frankly, counsel should have recognized that these things occurred.
Would he have had standing to raise all those issues?
He would have had standing to raise them with respect to Andrade's consent. He could have argued that Andrade's consent was not validly given. And even though he might not have standing to challenge, my client wouldn't have had standing, say, to challenge the warrantless search of the backyard. He certainly has standing to challenge consent given by another that ultimately results in a search that my client has standing to challenge.
But without a motion for new trial, how do we know from this record that Andrade might have recanted his consent?
That Andrade might have recanted?
The police testified that Andrade consented.
Yes.
And you're arguing that trial counsel was ineffective for not moving to suppress, saying that the consent was invalid. But we don't have anything that says Andrade would say, oh, I didn't really consent, or I only consented because the police made me, or we had a deal that I was only allowed to consent up to the curtain.
Well, Your Honor, I don't think that that's really the question here as to whether Andrade would have revoked his consent or not. It's ultimately, on any of these issues involving tainted consent, it's whether the prior illegalities impacted, they tainted the consent in some way.
You don't think it's relevant if he got on the stand and said, no, I wanted the police to come in. This is my parents' place, and I won't, I thought everything. I mean, you're saying that he wouldn't, his actual intent in the consent doesn't matter?
No, and I've never seen a case where, the consent analysis has never had, so defendants say challenging, let's take the third party out of it, say a defendant just challenging his own consent as being invalidly given. I've never seen a case where the defendant in that situation has to prove or testify that I wouldn't have given consent if not for these other, the illegality.
Well, he has to file an affidavit in support of the motion to suppress, or in support of the motion for new trial, saying I didn't consent.
He doesn't have to file an affidavit to say that I didn't consent. He just has to prove that his consent was in some way brought about by, or impacted by the prior illegalities.
So what should the police have done when they got the shot spotter alert and went to the house and saw the neighbor who said, yeah, he just heard a loud pop?
When they came and talked to Barboza.
Right.
They could have searched the driveway area.
Well, they found a shell, right? A spent shell in the yard.
But the shell is within the curtilage of the home.
But wasn't there an argument that there was, given the fact that there were shots fired that they were responding to, and they, were able to pinpoint it to that yard, that you're saying that they did not have, there was not exigent circumstances that would allow them to go into the yard at least?
I combed through plenty of cases on shot spotter. I've not come across a single case that says a single shot spotter alert would qualify for the exigent circumstances exception to the warrant requirement.
Even corroborated by Barboza's statement?
I don't think even corroborated by Barboza's statement. I would quibble with that to some extent because I think Barboza's statement is given when they're already in the yard. But even if they have Barboza's statement doesn't corroborate much. It doesn't say, I saw a gunshot. It says, I heard a loud pop, which is essentially what ShotSpotter, that's the same information that ShotSpotter would have given. If there was other information that there was in fact a gunshot here, then certainly I think they would have been justified in entering the yard. But at the point that they enter the yard, all they have is the shot spotter alert and Barboza's statement, I guess, and again, it depends on whether the statement was given in the yard or not. But based on that, just that alert, that's not enough to enter the curtilage of the home. And again, I haven't located any cases. In fact, I've located cases essentially saying the opposite, that say that a single shot spotter alert's not even enough to establish reasonable suspicion. So that would be my position with respect to the warrantless entry into the backyard.
Okay, so we're over time, but let me just ask if there's any other questions. Okay, thank you.
Thank you, Your Honor.
Good afternoon. If it pleases the court, Arna Hans for the Commonwealth, representing the Plymouth County DA's office. With respect to the first issue, the Miranda warnings. So Miranda warnings are only required when the defendant is in custody and there's formal questioning by police. So there's two conditions that need to be met. And here, the motion to suppress judge got it correct. There was really no evidence that the defendant was arrested or was restrained in a way that is associated with formal arrest. And then the second issue is there wasn't any explicit, or there was explicit questioning, but that portion of it was suppressed. And I'll get into those details later. But with respect to the statements that are in dispute here, there wasn't any formal questioning. Now, with respect to the four factors discussed by my brother, The place of interrogation, I would suggest that's not custodial. So normally a police station would be considered custodial. Outside of a police station or a prison, you'd need to have some further restraints. The examples that are often cited are the defendant's in handcuffs or he's in the back of a police cruiser. Neither of them happen here. He's just standing in someone's backyard. The fact that the officer conveyed their belief to the defendant that they were a suspect was is the second factor. That didn't happen here either. The fact that the defendant may have overheard a conversation between Detective Almeida and Sergeant McDermott about how they're going to go about the investigation did not relay to this defendant that they believed that he specifically was the one who was responsible for discharging that firearm. So that, again, bodes in favor of the Commonwealth. Nature of interrogation, the defendant has conceded this point, it was informal questioning. In fact, at issue here is Detective Almeida's question, who said that? Which I would suggest isn't interrogation at all. It's just a question about who made that statement. I need to identify you so I can continue my investigation. He can't Mirandize anyone until he finds out who made that statement anyway, so it's logical for him to ask that question when he doesn't know who initially said, hey, that firearm is mine. And of course, free to leave, I think it was not disputed that he wasn't free to leave. But again, this one factor shouldn't be dispositive in this case. The case is very similar to the ones that I cited, including Fisher, Tejeda, as well as Cawthorn, where in each of those cases, the first three were in favor of the Commonwealth, and the fourth one, where the defendant wasn't in fact free to leave, wasn't dispositive of the issue. Now that brings me to the second portion of the analysis, express questioning or its functional equivalent. So what we have here is the detectives go into the house after they get, or the garage, get consent, find the firearm, they go back outside, they're having a conversation about how to proceed with the investigation. They're talking to each other. The defendant happens to overhear this and says, confesses, it's my firearm. Detective Almeida says, who said that? The defendant then reiterates, it's my firearm, no one else was involved, and I'm the one who shot the gun. He says, I let one off, which the detective understands means I shot the gun. The detective then asks him a follow-up question saying, okay, what type of gun is it? And it's identified as a 9mm Ruger handgun. That portion of it was suppressed and didn't come in, and Judge Clifford was correct because that's, I would suggest, is an express questioning designed to elicit an incriminating response. By asking him what kind of gun it is, you're confirming that he has knowledge of, what firearm was recovered. So that was appropriately suppressed. So all we have here is Detective Almeida asking the question, who said that? And without any other prompts, the defendant has spontaneously volunteered, it's my gun twice, he shot the gun, and nobody else was involved. So certainly there was no questioning here. Notwithstanding that, if the court were to disagree with me, as Justice Tan pointed out, this wasn't the only portion of the evidence that suggested the defendant was the one responsible for possessing that firearm. His fingerprints were on the magazine, which were found inside the gun, and he was the only one in the location in the garage where the firearm was found. And on top of all of that, he was found not guilty of discharging the firearm, so the fact that he then subsequently admitted that he was the one who discharged the firearm really had apparently no effect on the jury, and there's obviously no prejudice where he was found not guilty of that. If there's no questions on that portion of the argument, I'll move on to the second argument. Now, with respect to whether or not trial counsel was ineffective, as the court may know, raising this issue on direct appeal is possibly the weakest way of doing it because the facts that we might need are not readily available before the court and they haven't been developed. The search of the backyard was certainly warranted by exigent circumstances, and I think the Ford case is very clear on this, and I also cite two, Moore and Paniqua, which are older cases where instead of entering, so I'll concede that the curtilage is protected and you would need exigent circumstances to go there as an initial matter. But in those two cases, Moore and Paniqua, they went into someone's apartment because of reported gunshots. This was certainly substantially less invasive where they respond to the residents, they get confirmation that somebody heard a loud bang consistent with a gunshot. The exigency continues when they get that information. They go into the yard, find the shell casing, and the exigency continues. Then they hear noises in the garage, and then they knock on the door to the garage. Officer Benzie doesn't enter. Sergeant McDermott takes over. He seemingly steps inside the garage. Now, it's unclear how far he enters into this structure, and that's actually a very important fact here. And it wasn't developed at the initial motion because the issue wasn't raised and it wouldn't have been important to do so. It could be very determinative of the issue here because if he's stepping into the threshold of the garage, if he's in the doorway, it really doesn't matter. And it appears that Sergeant McDermott at least knows better than to enter the building because he asks everyone out and then gets consent to search the building prior to actually searching it. That would, again, the record would reflect or suggest that he didn't actually go too far into it. Notwithstanding, even if he did enter it, it's very clear from this record that nothing came of it. Everyone was asked out of the building, and that's when they identified Silvio Andrade as the owner or the resident of that building who had the right to be there. He gave consent. There's nothing to suggest that that conversation took place inside the building because they asked everyone out first, and they pat-first everyone and did warrant checks on everyone prior to searching the garage. And then, as a result of this consent, they then enter the building and a different officer finds the gun. So nothing that Sergeant McDermott did prior to that led to the discovery of this firearm, which I think is an important distinction. Are there any questions?
Did you want to address the sleeping juror issue?
Yes, I can certainly address that. So there was no abuse here. It's the defendant's burden to establish that the judge's response to a report of a sleeping juror was either, excuse me if I may have a moment. All right, arbitrary or unreasonable, and that certainly wasn't the case here. The case law
Nothing
said,
was done, was it?
Hmm?
Nothing was done as a result of the report of sleeping jurors.
I disagree. So I think factually speaking, what happened here was the issue was raised on the redirect of Chris Hill, who was the officer in Brockton who was responsible for ShotSpotter. So it's at the end of his testimony, at the end of the first day of trial. His testimony continues, so the ADA brings up the issue. There's a conversation that's had. She believes that one of the jurors might be nodding off. The judge takes note of it and says, okay, how about we have a recess? How much longer do you have with this witness? And the ADA says, we're almost done with this witness. And then the judge says, okay, we're going to take a break in between this witness and the next witness. There is, I believe, 1 or 2 pages of follow-up questions from Chris Hill before they take a break. So I think the judge, rather than ignoring what was raised, had multiple options, and it's a graduated step. So the first one is acknowledge the receipt of the complaint and continue to monitor the situation. The next one is have everyone stand up and stretch. The next one is take a recess, and then the last one is to do an individual voir dire of the juror to assess how much they were sleeping and what they've missed. I would suggest to the court that the third step was taken. Shortly after Chris Hill stopped testifying, and I think it's within minutes, because there's maybe 1 or 2 pages of the transcript before the break is taken, a break is taken, which I think was the appropriate remedy here. Because there is a very big distinction between the cases where they say you can take a break or a stretch. You know, that's where you notice someone nodding off initially, you get it, you intervene right away, and that's the appropriate remedy. When you have to have an individual voir dire, it's at the point where somebody has been sleeping for a prolonged portion of the trial. And I cite the cases with respect to Villalobos. The juror had fallen asleep several times during the trial, and that was raised. With BRAUN, 3 independent sources in the courtroom said that one individual was sleeping during the presentation of the case. And then McGee itself, the case that one of the seminal cases here, the juror was snoring. So one of the other jurors approached the judge and said, this person has been asleep and they're actually snoring.
Is there any further discussion in the remainder of the transcript of whether or not that juror was dozing or whether or not the stretch break did the trick?
No. So the issue isn't brought up again. So this would have been at the end of the first day of the trial, or I think there was one more witness at it, but it was like page 187 out of 200 something in the transcript.
Well, wouldn't it behoove the prosecutor, especially when she's the one who brought it up in the first place, to put something on the record?
Just to say this person hasn't been sleeping in?
To say, may the record reflect that the judge had taking a bathroom breaks apparently made the jurors more alert?
I don't know if that burden's necessarily on the prosecutor here. There is a case that I cited, and I believe it was Dancy, but I refer to my brief, where they did take a stretch or a break, and there doesn't, from the transcript, it doesn't appear that it was an issue anymore. And so the appeals court decision specifically says that it wasn't raised again and it wasn't a problem anymore, and then they moved on. So I don't know if there needs to be an affirmative response from the prosecutor. I think the fact that the record is silent to the issue would suggest that the issue was resolved. If there are no further questions, I'll rest on my brief.
Thank you.
Thank you.
Thank you to the parties. Let me check. Are we done? Done? Okay. That concludes our sitting today, and I want to thank everyone involved in making this court sitting possible. And this case is submitted, and the court session is completed. Thank you.
Good argument.
Have a good one.